Thank you for attending Racial Disparities in Criminal Sentencing and Drug Court Eligibility. The Drug Court webinar series is hosted by The Ohio State University Moritz College of Law, Drug Enforcement and Policy Center, The Ohio State University John Glenn College of Public Affairs, the Cornell University Brooks School of Public Policy, Department of Sociology. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you so much, Holly, and thank you to all of you attending today's drug court webinar. Hello and welcome. Really grateful to be able to be the host. My name is Douglas Berman. I am a professor of law here at The Ohio State University Moritz College of Law, and I also help to direct the Drug Enforcement and Policy Center. And this is the second in our June webinar series. This particular webinar series is presenting findings from research on drug courts in Ohio, with this session giving particular attention to access to drug court programs. And this second webinar presents results specifically from an analysis of Franklin County sentencing data. We're going to start by having a presentation of the study findings, followed by a Q&A session that I'll begin, but then hopefully have time for some questions from the audience. To start, the study introduction will be presented by Dr. Tasha Perdue. Dr. Perdue is an assistant professor at The Ohio State University's John Glenn College of Public Affairs and affiliated faculty here at the Drug Enforcement and Policy Center. Her research focuses on substance use, service systems, and policy responses using mixed methods to inform evidence-based intervention that improve outcomes for individuals, families, and communities. She currently serves as MPI on NIJ-funded research, examining overdose response and system-level approaches to supporting families. Results will then be presented by Lydia Applin. Lydia is a third-year PhD candidate at the John Glenn College of Public Affairs at The Ohio State University. She's interested in researching criminal justice policy and public services, including policing and juvenile justice. We will then be joined in the Q&A by Dr. Sade Lindsay. Dr. Lindsay is an assistant professor in the Brooks School of Public Policy and Department of Sociology at Cornell University. Her research examines how criminal justice policy can both alleviate and reproduce social inequalities, and she gives particular focus on incarceration alternatives for substance use disorders, vocational and educational opportunities in prison, and economic mobility during re-entry. So you hear we have an all-star panel to discuss this research. At the conclusion, I'll start our Q&A session with a few questions, and then we'll turn it over to audience questions if we have the time. As a reminder, please feel free to submit your questions throughout the presentation. And at this point, I'll now turn this over to Dr. Perdue to discuss the study.
Thank you for joining us for the second webinar in our drug court series titled Racial Disparities in Criminal Sentencing and Drug Court Eligibility. My name is Dr. Tasha Perdue, and I'm here with Lydia Applin to present these insights. Today, we'll share administrative data and analysis results from our study, which examines how racial disparities in substance use case sentencing result in differences in drug court eligibility. We'll discuss our research findings that Black defendants have a greater likelihood of having criminal records that may later become the basis for drug court exclusion. The findings we're presenting today are from a project that was supported by an award from the National Institute of Justice, Office of Justice Programs, U.S. Department of Justice. The opinions, findings, and conclusions or recommendations expressed in this webinar are those of the authors and do not necessarily reflect those of the Department of Justice. The project team consisted of 3 principal investigators, including myself, along with Dr. Sade Lindsay and Dr. Alex Fraga. Dr. Fraga led phase 2 of the study, which is the phase we'll be presenting today. The purpose of this study was to explore access to Ohio drug courts, with particular attention to differences in access according to race. Phase 1 of the study examined how adding specialized dockets in Franklin County shifted probation and jail sentencing for substance use cases. This phase also assessed how changes in sentencing varied by race and sex subgroups. Phase 2, which is the focus of today's webinar, analyzed differences in sentencing by race. In particular, this phase assessed how differences in sentencing impacted people's drug court eligibility. Phase 3, which we discussed during the last webinar, explored how drug court team members describe differences in drug court access. During this phase, we asked team members about the mechanisms behind differences in access, along with proposed strategies for addressing them. Again, we'll be focused on Phase 2 findings today. Existing research has demonstrated the effectiveness of drug courts at reducing recidivism and substance use, increasing employment and income, and improving family relationships. Much of the existing research on drug courts has focused on specific outcomes, such as recidivism or graduation. And as a result of this research, we can see that drug courts provide benefits for participants and the broader community. But we know less about other aspects of drug court programming. While research has demonstrated benefits from participation in drug court, past research has also established that there are disparities in drug court populations. What this means is that among similarly situated white and Black clients, white clients are disproportionately overrepresented in drug court populations. Black clients are comparatively less likely to be admitted into drug court. There has been limited research that looks at potential sources of these disparities in drug court populations. Therefore, we were interested in understanding pathways into drug court and how eligibility impacts drug court access. One key area which impacts someone's access to drug court is program eligibility requirements. Many programs exclude people with certain offenses on their criminal record, including selling or trafficking drugs, gang involvement, violent offenses, sex offenses, or weapon offenses. These eligibility criteria have historically been presented in best practice standards and funding and certification requirements. Multiple decision points in the criminal justice process may impact someone's eligibility for drug court, including the offenses they're charged with, the offenses they're convicted of, the offense types, and the degree of these offenses. There's a lack of research that examines how racial disparities may arise across multiple decision points. The study we're presenting today looks at multiple decision points, including convictions, offense type, and degree of offense. Further, these outcomes may vary depending on offense type, and this is also relevant for drug court eligibility. These lists of offenses often exclude someone from participating in drug court. We sought to examine if there are racial disparities in sentencing for these specific offense categories that impacts drug court eligibility. A key question that arises is how might sentencing for these offense types be different for white versus Black defendants? For example, take two defendants arrested for the same offense, alike in every relevant way except for their race. Suppose the white defendant has their charges reduced to a lesser offense or dismissed, while the Black defendant has their charges escalated to a higher degree of offense and is ultimately convicted. This conviction is then used to exclude the Black defendant from drug court, even though the underlying behavior was identical. So an eligibility rule that appears race neutral on paper ends up inadvertently carrying forward or reinforcing disparities that come before it. Our analysis explores these phenomena. With that, I will turn it over to Lydia, who will present the analysis and research findings.
Thank you, Tasha. So to explore how racial disparities may impact drug court eligibility across these different decision points, we used misdemeanor and felony criminal case data from Franklin County, Ohio. You can see on the map where Franklin County is located. This is where Columbus is. So the resulting misdemeanor data set included over 306,000 misdemeanor cases from 2006 to 2020 in the county. For each case, the defendant's demographic information, including race, was included. And also for each case, we had the number of charges on the case, the charge severity, the offense type, and a measure of criminal history going back to 2001 was also included. Within this misdemeanor data set, a majority or nearly 52% of the defendants were white, 44% of them were Black. And also over 2/3, or about 71% of the defendants in this data set were male. Among the misdemeanor case offense types in the misdemeanor data, Black defendants were more likely to have violent or drug charges, while white defendants were more likely to have alcohol charges in this time frame. In addition, while nearly 2/3 of all defendants had M1 charges, which were the highest degree of misdemeanor charges, Black defendants were more likely to have minor misdemeanor charges as their highest degree of offense. So again, this is capturing the highest degree among all the charges on their case. And then nearly all felony cases in Franklin County start out in the municipal court before being transferred to or filed in the common pleas court. And using case identifiers, we were able to track over 57,000 cases from 2006 to 2020 from the municipal to common pleas court. This data sample ultimately represents approximately 52% of all felony cases in Franklin County during this time frame. The remaining cases couldn't be tracked due to administrative errors or missing data in the data set. So as with the misdemeanor data, all felony cases that we had in our data set included demographic information, including race, along with legally relevant variables such as criminal history and offense severity as well. And unlike the misdemeanor data, a majority or 53% of the defendants in the felony data were Black, while about 43% of them were white. And when it comes to the offense types in the felony data set, again, Black defendants were more likely to have violent charges in this data set, and they were also more likely to have weapons charges, while white defendants were more likely to have property and alcohol charges. Very similar proportions of white and Black defendants had drug and drug trafficking charges in this data set. When we looked at the degree of charge when the case was initially filed in the municipal court, so this is the first decision point at which charge filings can differ. So again, this is when the felony charge is initially charged in the municipal court. At this point, we see that Black defendants are generally more likely to have more severe felony charges. So a greater proportion of them have F1, F2, or F3 felony charges, while a greater proportion of white defendants have F5 felony charges in this data set. And then at the second decision point, when the case is filed in the common pleas court, at this stage, charges can be reduced to misdemeanor charges. And we see at this stage that a greater proportion of white defendants have their charges reduced to misdemeanors. Further, we again see that Black defendants are more likely to have more severe felony charges, so F1, F2, or F3 charges. So within both the misdemeanor and felony data sets, we compared outcomes between white and Black defendants. We controlled for age, sex, criminal history going back to 2001, the number of charges they have on their case, the highest charge severity, so whether it's an M2 or an F4 or so on, and the primary charge offense type, so whether it's a property charge, a weapons charge, and so on. So this means that we ultimately compared groups of defendants who are identical across all of these dimensions and for whom the only difference between them was their race. Of note, since most cases and many of the cases involve multiple charges on a single case, the analysis uses the highest level or most severe primary charge for the analysis. So, for example, among males who are in their early 30s, around the same age, who have very similar cases and criminal histories, and who all received M1 property charges, we ask what's the probability that a Black defendant has their charge reduced relative to the white defendants in this group. Or for another example, within all of the males who are in their late 30s with similar case and backgrounds and similar case circumstances, all of whom who received F2 violent charges, for example, what's the probability that the Black defendants receive a conviction for this charge relative to the white defendants in this group? So this is the type of analysis that we used for both the misdemeanor and felony data sets across the different offense type categories. So we'll dive into the results in greater detail shortly, but just to provide you with an initial overview of what we found, when compared to identical white defendants, Black defendants were more likely to be convicted of an offense when charged, especially at the misdemeanor level. Black defendants were also less likely to have their charges amended to a lesser offense, again, especially at the misdemeanor level, and then when the cases were filed in the common pleas court as well. And ultimately, Black defendants were less likely to experience leniency, and they experienced greater charge rigidity in sentencing for offense types that are used to exclude people from drug court. So we see this is especially true for violent, weapons, and drug trafficking offenses. So in our overall analysis, before we go into details about specific offense types, just overall, we found that when compared to white defendants, Black defendants in misdemeanor cases were 8% more likely to receive a guilty conviction for the original charge on their case. This means that they experienced greater charge rigidity. And relatedly, they were 9% less likely to have the misdemeanor charges reduced. When the cases were filed in the common pleas court, Black defendants were also 5% less likely at this stage to have their charges reduced compared to white defendants. So this means among defendants with the same age, sex, criminal history, and charges on their case, the Black defendants were ultimately less likely to receive a charge reduction than white defendants at both the municipal and common pleas levels in our data set. So overall, again, this demonstrates greater charge rigidity and less leniency for Black defendants compared to white defendants. However, we see even greater and more severe disparities in outcomes when we separate by offense type. So next, we'll discuss those results, paying particular attention again to the offenses that exclude people from drug court. So starting with violent offenses, we saw considerable differences in case outcomes for violent offenses. At the misdemeanor level, when compared to white defendants, Black defendants were 5% more likely to receive a guilty conviction for the original charge, and they were 23% less likely to receive a charge reduction. So as an example, suppose two defendants have identical cases and criminal histories, and they're the same age and sex, but one is white and one is Black. The Black defendant is then 23% less likely to receive a charge reduction at the misdemeanor level. Even though the underlying behavior is the same for both defendants, the outcomes are different, such that the Black defendant may be excluded from drug court because of this conviction or this charge, while the white defendant may not. Again, this demonstrates considerably more rigidity and less leniency for Black defendants. And similarly, at the felony level, Black defendants were 16% less likely to receive a charge reduction when the case was filed in the common pleas court. Again, the outcome is that even when compared to similar white defendants, Black defendants were more likely to end up with a violent offense on their record when charged, which often results in categorical exclusion from drug court. We saw the most consistent and severe disadvantages when we looked at weapons offenses in particular. So compared to white defendants, Black defendants were 18% more likely to receive a guilty conviction for the original charge. They were 60% more likely to receive an upward charge escalation, and they were 20% less likely to receive a downward charge reduction. The charge escalations and reductions occurred when the case was filed in common pleas court. So at this stage, we see pretty severe disadvantages. So again, just as another example to make this easier to sort of understand what this looks like in practice, suppose you have two defendants with identical cases and backgrounds, and the only difference between them is their race. When the cases are filed in the common pleas court, the Black defendant is significantly more likely to have their charge escalated to a more severe charge. The white defendant is more likely to instead receive a charge reduction. And the result is that the Black defendant is more likely to end up with a conviction that could categorically exclude them from drug court, even though both defendants engaged in the same underlying behavior. So like other offense categories, we see that Black defendants experienced less leniency and overall were more likely to ultimately accumulate weapons charge convictions, which again could exclude them from drug court participation. We also saw disadvantages when we looked at drug trafficking charges as well. So compared to white defendants, Black defendants were 69% more likely to receive a guilty conviction for the original charge, and 38% less likely to be convicted of a lesser included offense on their case. Like we described with other offense categories, this means that for identical cases for Black versus white defendants, the Black defendant is much more likely to have their charge stick and less likely to be convicted of a lesser offense in their case instead. Again, this demonstrates that Black defendants see more charge rigidity and less leniency for drug trafficking offenses, which again could similarly exclude them from eligibility for drug court. When we looked at non-trafficking drug offenses, we saw similar disparities. So when compared to white defendants, Black defendants were more likely to receive a guilty conviction for the original charge at both the misdemeanor and felony levels. They were less likely to receive a charge reduction overall, and also less likely to be convicted of a lesser included offense at the felony level. So overall, we continue to see similar trends with drug charges, including greater rigidity and less leniency for Black defendants in these sentencing outcomes. We saw even more extreme differences when we looked at alcohol offenses. So compared to white defendants, Black defendants were 57% more likely to receive a guilty conviction on the original charge in the misdemeanor court. When the case was filed in common pleas court, they were 50% less likely to receive a charge reduction and ultimately 63% less likely to be convicted of a lesser included offense. So these are pretty significant differences for alcohol sentencing for Black defendants. When we looked at other offense categories, we saw surprisingly different trends. So among property offenses, when compared to white defendants, Black defendants experienced relative disadvantages at the misdemeanor level, but counter to what we see in other offense types, they experienced relative advantage at nearly every decision point at the felony level. This includes that Black defendants were 8% more likely to receive a charge reduction when the case was filed in the common pleas court for property offenses. For public order crimes, the only significant difference observed was that Black defendants were 4% more likely to receive a guilty conviction for the original charge at the misdemeanor level, but there was no difference in outcomes at the felony level for public order charges. So to sort of summarize all of our findings, this table shows each decision point in our data, along with whether Black defendants encounter disadvantage when compared to white defendants. So this table, the way to sort of interpret this, this is the results from the misdemeanor data set. Every square that has a red minus sign indicates that Black defendants experience disadvantage at this stage. So we can see that Black defendants with misdemeanor charges encounter greater charge rigidity across all offense types for misdemeanor cases. They also encounter less charge leniency for 3 of the 6 offense type categories, as well as for overall cases in the misdemeanor data set. This is a similar table for the felony data that shows advantage and disadvantage for Black defendants across these decision points. So the first 2 columns show what this looks like when the case is initially filed in the municipal court and then moved to common pleas court. And then the second 2 columns show the ultimate case outcome in the common pleas court. So we can see for every offense type, other than property offenses and public order offenses, Black defendants experience some level of disadvantage during at least one point. So if we go across every row, we see at least one red square for drug trafficking, alcohol offenses, violent offenses, and weapons offenses for Black defendants. And for most offenses, there is disadvantage at multiple points. For weapons offenses in particular, Black defendants encounter disadvantage at every single stage in the system for felony cases. But then conversely, Black defendants encounter advantages across the system when it comes to property offenses, which is a surprising difference in these trends. So ultimately, these findings underscore how small differences compound across multiple discretionary decision points. And while disparities at each decision point may appear modest on their own, charge amendments and convictions across multiple points in time, and for many, across multiple encounters with the criminal justice system, can all accumulate into criminal records that later determine eligibility. And thus, drug court eligibility is often based on records that have already been shaped by disparate treatment, particularly for Black defendants. So to address these gaps in eligibility and drug court access, we have a series of strategies to present. And again, these were collected from stakeholders who work in drug court. These are some of the similar strategies that we presented from our phase 3 findings. So one such strategy is to expand eligibility criteria. And certainly this depends on funding or certification constraints, but courts may be able to expand criteria to reach additional populations. One example of this is to eliminate certain offense restrictions, and this would allow courts to reach additional groups of people who otherwise might not be able to access drug court due to these disparities in sentencing outcomes. Further, courts can make more individualized admissions decisions. So rather than relying on overarching criteria that sort of apply like a blanket exclusion, they can make decisions on a case-by-case basis that may help address previous differences or disparities in sentencing outcomes. Courts can also adopt additional screening tools to make more holistic admissions decisions that go beyond criminal history or just what's on somebody's criminal record as well. Another strategy is proactive case identification. So we observed some courts who sort of go out of their way to seek potential participants rather than simply waiting for referrals. and this can help address some of these disparities as well. Lastly, courts can collect program data to assess their program population and the composition of their population and identify gaps in reaching different people and groups. When describing some of these strategies, one probation officer we talked to shared, we now can take referrals from pretty much everyone or anyone, and we see that as better, and we're ultimately getting better diversity in our program. So this example shows that expanding some of these methods or using some of these strategies for sourcing drug court participants can help courts ensure that they're reaching additional people and groups. And overall, we see that there are a variety of strategies that courts can use to address racial disparities in their program populations. So like all research, the study is not without its limitations. One is that we strictly focused on Black versus white defendants, and we were unable to look at other racial groups due to sample size limitations. Similarly, we were unable to conduct race and sex intersectionality analysis due to sample size limitations as well. So we initially wanted to explore how people from certain intersectional groups or subgroups experience disadvantages in case sentencing, but limited sample sizes from certain groups of people prevented us from doing so. Further, as mentioned before, we were unable to match the full sample of felony cases from the municipal court. There was no systematic pattern across the cases that were excluded from our data sample, but this still remains a potential limitation. And lastly, our criminal history measure only captures criminal history in Franklin County and not beyond. So this is another thing to note. So overall, the study demonstrates that racial disparities persist across multiple decision points in the criminal justice system, and Black defendants overall experience greater charge rigidity and less leniency in case outcomes. This is especially true for offense categories which often exclude people from drug court, including violent, weapons, and drug trafficking offenses. As a result, racial disparities in case sentencing impact drug court eligibility and access. However, as we discussed, there are a number of strategies that courts can use to address these disparities in their admissions processes. Here are a list of all reference sources from throughout the presentation. And thank you. We look forward to answering your questions and discussing these findings further. And with that, I will turn it back over to our moderator, Doug Berman.
Thank you so much, both Tasha and Lydia, for that truly insightful and informative and data-rich presentation. As I try to simplify some takeaways, I see the study overall highlighting how disparities in criminal case processing, especially at the sentencing and charge stages and outcomes, can shape access to drug courts in quite significant and meaningful ways. And we see how, if I get this right, even small differences across decision points can accumulate over time, resulting in unequal eligibility for treatment-focused alternatives. And I think these findings underscore the importance of examining not just program effectiveness, but also who has access to these programs in the first place, which has its own then downstream effects. I think they also point really effectively to practical opportunities for courts to promote more equitable access moving forward in light of your findings and understanding its implications. And so as part of an effort to make sure I've got it and then give you all a chance, and I think Dr. Lindsay is going to be joining us as well. At this stage, I've got a few questions to kind of reinforce what I see as some of the big themes, and then the audience is welcome to use the Q&A to start teeing up some questions, and we'll try to get to those as well before the end of the hour. My first question is, at this high level, as I understand it, you found that Black defendants experience more, I think you call it charge rigidity and less leniency. And so could you explain what that means a little bit more in practical terms for someone moving through the system? Is it useful to be thinking of individual defendants, as they hit each of these decision points? Is it worth thinking about it more, kind of as a group matter? How should we continue to understand your findings about charge rigidity here?
Yeah, so I think what we see is that for someone who's moving through the system, there's both an increase in active punitiveness that they encounter, that Black defendants encounter, as well as perhaps an absence of leniency or the same sorts of opportunities that white defendants encounter in the system. So, for example, we saw certainly some cases of case escalations, but these were rarer. And what was more common is that Black defendants were less likely to receive charge reductions or convictions for lesser included offenses on their cases. So this trend doesn't necessarily reflect like an addition of punitiveness that Black defendants face consistently across every stage, but rather they don't enjoy the same lenience that white defendants face in our data set, at least. So when this occurs across multiple points in the system, and again, potentially across multiple encounters with the criminal justice system, the result is a compounded series of disparate outcomes in which Black defendants may end up significantly worse off compared to identical or otherwise similar white defendants. I don't know if Tasha or Sade have other thoughts to add on that question as well.
Yeah, I think Doug brings up an interesting point in terms of like, are we focusing on individuals or should we be thinking about this sort of as a group process or with group implications? And I feel like it's hard to know, right, at what stage, like in terms of policing versus prosecutors, like where the difference might be emerging per se, right? Could be that maybe the policing strategies or what's found in the evidence, et cetera, right, might be more convincing or robust, right, for Black defendants, which is still, right, inherently can filter in that bias. And so it is hard to think about at least at what stage we would be trying to address the disparate impacts right away, which is, for me, sounds more like a system kind of issue. There's not really a point that, not to blame, we're not trying to do that, but like somewhere that we can sort of tackle the issue. It's sort of structural and institutional in a way.
Tasha, I didn't know if you, Dr. Perdue, I didn't know if you wanted to jump in. I saw a question in the Q&A that I kind of want to attach to this conversation because I think it's a really interesting component of this, especially when we're thinking about, as Lydia suggested, that this is perhaps a kind of disparity or you might even call it discrimination in leniency and mercy, that there's less willingness to downgrade an offense or to process it. And again, Dr. Lindsay, it's hard to say at what stage of the process that's going on, but wondering if maybe victims have a role here, that a component of what may be influencing different charging or sentencing processes is, and Marsy's law is here in Ohio. It's in a number of other jurisdictions. Even states without Marsy's laws often provide opportunities for victim input, and whether it's possible that we see some differences. It's another decision point in which the victim's input may influence all the case processing actors, and that's another way in which we see disparities in how charges and sentences move forward. I don't know if is there any way to sort of identify that in the data, or if that's at least a plausible accounting of another factor that may be shaping the data you're finding.
Yeah, so I think that's a really great question about victims. We don't have data to kind of measure that per se, but just thinking about even right, there's in terms of like intra-racial crime and victimization are highly entangled. And so, right, if communities are already distrustful of a system, maybe victims don't show up and don't, or their families, et cetera, don't partake in the sentencing versus other families may show up in a way. And in the same way with the defendants, maybe, right, there's resources and other sorts of factors that might be driving some of these disparities as well that we can't really account for. I mean, resources really come to mind in terms of your attorney and your ability to know about these resources, the drug courts, and to just have someone, right, who has that kind of knowledge to support and getting more leniency, essentially. So it's hard for us to know, but the victim piece is, I think, an interesting question that I don't think our data would allow us to at least answer empirically.
Yeah, I think these are always very challenging things to pinpoint, especially as we were talking about the decision makers sort of accumulate on each other and the impact that a victim may or may not have, or even how, like you say, a defense attorney may know to interact with a victim in terms of giving them some satisfaction without them turning to the prosecutor and saying, I want this charge or that charge, or influencing decision making that way. All right, I want to move on now to, I'm not sure they're quite solutions, but at least ideas about how to respond to what you all are finding. And that's specifically this idea of expanding eligibility criteria for drug courts. I'd love to hear more about kind of what that means in terms of a way to address some of what you're finding. And I guess even more so about kind of what the opportunities and challenges that may be there as we potentially approach that solution. Is that something that needs to be done at the legislative level? Is this something that can be done, court by court, depending on how the drug court's organized? Is it something that even maybe prosecutors and defense attorneys, other system actors can seek to address? Love to hear more about the idea, especially because it does, strike me as quite meaningful against the backdrop of the data you're showing that some people just end up with a barrier to entry that really doesn't reflect differences in underlying behavior, just reflects differences in how the criminal justice system has processed that behavior.
Yeah, I think some of the biggest challenges to implementing some of those strategies for individual courts would probably be like funding constraints. So oftentimes, depending on the funding sources, courts are often constrained in some of the eligibility criteria. Um, and that can certainly be really difficult for courts to sort of navigate, especially because courts certainly rely on funding to be able to operate their programs, and there might not be many alternative sources of funding. So that can be one really big challenge. I think another thing, you mentioned attorneys and other actors in the system. I think getting buy-in from other actors as well can be a challenge. So if attorneys or other judges or other sources of referrals, if they're not necessarily bought into drug court, or if they're not on board with the treatment court model or what these programs are doing, then even if we expand eligibility criteria, courts may still encounter challenges in seeking referrals for different populations in similar ways. So I think that's certainly another challenge as well. I think some of the opportunities, though, is there is like a really big chance to expand the treatment access to people who otherwise wouldn't access it, which is a huge opportunity as we see that drug courts have profound impacts on individuals, on families, on whole communities, even. So I think that being able to reach some of these other populations it's a huge investment that would have a really big payoff for different communities. And also, it's an opportunity to sort of address or potentially correct some of these disparate outcomes that we see in sentencing, that we see in the data that we present today. So it's sort of a way to address a lot of these trends and the disadvantages that the Black defendants in these data sets encounter in particular. I'm not sure if Dr. Perdue or Dr. Lindsay have other thoughts on that question as well.
Oh, I'll let you go ahead.
Thanks. Yeah, I would say from the phase 3 interviews, one thing we heard very clearly is eligibility decisions are shaped by the formal criteria, but also by how these are interpreted and how they're put into practice. So I think one opportunity with expanding eligibility is that it creates space to move away from more of the rigid offense-based exclusions, as Lydia was mentioning, and towards more holistic decision making. And many stakeholders emphasize that people that excluded based on past charges may still be strong candidates for treatment. So particularly when substance use is a primary driver of their involvement in the system. And at the same time, we do see some challenges really coming down to the implementation, again, as Lydia mentioned. So stakeholders did talk about concerns, just managing the risk, manage the buy-in from prosecutors, judges, treatment teams. So There can also be hesitation around changing, these longstanding practices, especially when eligibility rules are, as Lydia had mentioned, tied to funding, certification standards, or even just local norms. So I think in practice, expanding the eligibility isn't just a policy change, but it really would require a shift in this how decision makers assess the risk, interpret the criteria, and define who is appropriate for the program.
Yeah, and I think as we focus on trying to like expand, right, eligibility, thinking about how programs should and could look would be important as well, and sort of the culture of the programs, so that, right, if we're expanding eligibility, we're ensuring that like we're setting people up for success as well. Some of the interview data from phase 3 talked about, right, some of the stigma that can come in from you having like a drug trafficking offense, and just some of those factors that would need to be kind of worked out culturally, but also, right, institutions and structures help that by setting sort of some of the basic legal, at least, norms and what's allowable. And then I do think the funding issue is another big one that came up a lot as well, especially with federal grants. So something like marijuana charge, right? That usually can get you kind of excluded in terms of if you want to get federal funding, but then also serve this population. And, you have to be you can't be using marijuana during the program, right? Those sorts of frictions that come into play that might push people out too as we start to expand eligibility. So.
And I want to give all of you credit and just praise this work more generally, because I think we've seen in recent years, not as much as I'd like to see, but a greater understanding that things like criminal history in general are not reflections of, the world as it is. They're reflections of the way in which the system interacts with individuals, and that there are a range of structural biases and determinants that end up shaping what sometimes the system then treats as, the gold standard of data, which it really isn't. And I think that's itself, ends up feeding back into your cultural points that, you need the system actors to themselves understand, hey, we see these disparities in what charges stick and what charges don't, and that itself should influence our own understanding of how rigidly to treat these eligibility criteria, and to recognize, as you suggested, Dr. Perdue, that there can be lots of good candidates for these programs, even if they check off one of the boxes that are supposed to exclude them. And so, again, kudos to this work, and grateful for helping to advance those sets of conversations. Speaking of data, though, and this will be my last question, a quick reminder to the audience, please feel free to throw some questions into the Q&A. I've got a couple there that I'm going to get to after my last official one, but please don't be shy to put a few more in. I think we're going to have time. There's mention at the end about the importance of collecting program data. I'd love to hear more. I'm always one of those academics that says, of course, we need more data and more data, and let's have some more data, and it would be great if we had some more data. But what particularly do you think should be measured to understand both, the drug court realities generally, but especially to be in a position to address the disparities that you've identified effectively? What kind of data do you have in mind? And we won't get yet to the funding to support collecting that data, but just eager to hear your now informed perspectives on really where we should be trying to do even greater data collection efforts.
Yeah, I think the biggest area is just the population composition in the programs. And in talking to different courts, we see a lot of variation in the amount and types of data that programs are able to or are currently collecting on their program composition. Some programs are able to sort of track over time how the composition changes, and I think that insight is really valuable, especially as courts might introduce different strategies or try different, things to expand referral pathways, or even some of the strategies that we've talked about in these last couple of webinars. Being able to see how those strategies actually do impact the population composition is really, really valuable. We have heard a couple different ideas about how to sort of identify gaps in populations. So some people propose, you should look at your drug court and see how it reflects the local community, maybe using census data or other local demographic data to make those sorts of comparisons. Whereas other people say, actually, it's more valuable to compare this to your probation data, who in your community is on probation, and ensuring that your drug court population is representative in terms of that population. I think that is a really valuable comparison. Now, that certainly requires some coordination with probation and collecting other sorts of data that way and making those comparisons. But that can be really, really valuable insight. Basically seeing, does my population match the types of people who could be in my program, the types of people who could really benefit from this program, from treatment. Um, and I think trying to make regular comparisons. So we know that, periodically courts have to submit data to the Supreme Court, or there may be like other timeframes for data collection. But the more frequently programs were able to say that they collected this data, programs were able to describe that that was really helpful, knowing every couple of weeks or every month or two, we are getting sort of fresh insights on what our population looks like, and we're able to make these comparisons. A lot of the stakeholders we talked to said that that was really valuable insight. So those are some of the things that we heard from drug court team members.
Yeah, and I think Lydia brings up a good point where there are some basic measures that, from the Ohio Supreme Court, that data that's submitted that programs must have. And so having someone on staff, whether that's writing someone into a grant or something, right, that they can analyze that data and do some of this work, because obviously we know that judges, prosecutors, et cetera, are super busy, and this is kind of where researchers can come in. And we use some of this Ohio Supreme Court data to sample for our qualitative studies. And so some of the data is there. It obviously could be better, but there's something that you can start with. But making sure maybe that's courts know that when they're submitting that data, that there is like a database, and they could request it and run some numbers, et cetera, or hire someone to do that kind of work, would be super helpful to at least just be in the know, right, about where they could be improving in terms of diversity or whatever other metrics that they're interested in.
Yeah, and I would add to that in phase 3, the stakeholders emphasize the understanding these disparities requires looking beyond who is ultimately admitted and examining the entire pathway through drug court. So tracking who is identified as eligible at early stages, who's being referred versus not referred, and where individuals are screened out and why. So participants noted that disparities often emerge before the formal eligibility decisions are even made. So during those initial interactions with the prosecutors, defense attorneys, or other court staff. So and some also provide as a way to provide this referral information back to the referral sources. So let them know that, this is who you have referred to us, and just keeping track of those numbers and letting the referral sources also know, so that they're aware of who they've been referring and what their numbers also look like. Also, it can be used as an accountability sort of metric as well. There's also strong emphasis on capturing that decision-making rationale, so not just outcomes. So, why was someone not referred, or what factors may have influenced that decision? So, and then really linking the data across system points. So as Lydia mentioned, so kind of maybe linked with probation and making those comparisons, and kind of seeing, how that looks within the broader court system. So rather than focusing only on who is in the program, understand that full sort of funnel and where those disparities are introduced along the way. And then I would also add, in addition to looking at those sort of numbers and the demographics who's participating, also engaging with the participants themselves. So taking time to understand participant experiences and really engaging with individuals who maybe opt out of the program as well. So get an idea of why individuals may be opting in, why they may be opting out, why they may leave the program. And really, several courts have implemented exit interviews that they're starting to collect this data, listening sessions, and then really not just collecting it, but also then using that data to inform their program structure. So it's one thing to collect the data, but then actually to use that and put it into practice. And then finally, with the transparency of data was also mentioned in interviews. So making sure that the treatment court team is, have regular conversations and make sure this data is accessible and that individuals can have this understanding and revisit it at a more frequent time period. So one participant noted, we may look at this once a year, but that may not be enough because individuals can be falling and not falling through the gaps and not being able to participate in the program.
So there's one question on the Q&A that relates to data that actually taps into sort of a broader set of stories. But the question asks, since mental health courts also work with co-occurring defendants, are they included in your data set? And for me, that's sort of the broader question of whatever is in your data set. Presumably, there are other sets of problem-solving courts, with family courts and veterans courts and the like, that also use eligibility criteria that we, though may not be able to perfectly generalize from your research, there's reasons to be thinking about whether there are the similar types of dynamics that your data show. But I guess first on the technical question, were you looking at mental health courts as well, or is that a different grouping?
Yeah, so for our project, we were focused on adult drug courts in particular. That was sort of just the scope of this project. However, we do know that many other treatment courts do use similar eligibility criteria. The data that we analyzed is all criminal cases in the county, so all misdemeanor cases and as many felony cases as we were able to match. So yes, people who ended up in other sorts of treatment courts, those types of cases were certainly included in our data. And because eligibility criteria are often similar, and especially because some participants may start out in adult drug court and then be transferred to mental health court or vice versa. I would expect that some of the similar strategies that we discussed or some of the similar phenomena that we found with our study would certainly apply to the mental health court context as well. So while that wasn't the primary scope of our study, I think a lot of the insights here still apply. And the same, disparate sentencing outcomes, certainly people who end up in mental health court settings, they face a lot of those same outcomes as well. So what our data shows applies to all defendants who are going through the criminal justice system, regardless of sort of what treatment court setting they may or may not end up eligible for or end up participating in.
Yeah, that's a great point. So here's one that asks, we are often told that the reason for case type exclusions from drug court is that certain offenses, arson, violent crime, sex offenses, make it impossible to place people in residential treatment programs, which are required in some drug courts, the drug court that this commenter is coming from. Is that something you have seen or heard, or is that somehow reflected in aspects of what the data captures and the research you've been doing?
Yeah, that is definitely something we heard. Sex offenses in particular, something we heard that very often exclude people from participating in or attending residential treatment due to the really complicated factors surrounding different sex offenses. And we excluded those offenses from our data analysis, again, just because those sorts of cases have a different sets of complexity around them. And yeah, some of the eligibility criteria with sex offenses are a little bit different. So that is something that we heard a lot with treatment providers. Interestingly, we did talk to a number of courts who said that they had relaxed eligibility criteria, had been able to admit more people with violent offenses or weapons offenses. And that wasn't something that came up as necessarily a barrier to them. Not to say that that wouldn't happen, but yeah, some of the courts we talked to basically showed that they were able to admit people with these sorts of crimes on their record, and they were still able to connect them to treatment successfully. But that definitely could be a barrier depending on the local treatment context. Also, certainly certain counties or certain regions just have access to more treatment providers than others. So in some counties, there's a real limitations in the number of treatment providers they have access to. And if there are only, a couple of them locally who they can connect their clients to, and if those treatment providers have these sorts of eligibility or exclusion criteria, that would be really difficult to sort of work around. But I think also some people discussed when they're able to identify cases on a case-by-case basis, I think then they're able to work with treatment providers in a different way and sort of explain the context and what's going on. And they might be able to sort of find ways to work with treatment providers to navigate some of that. But yeah, depending on sort of the local context, that can certainly be a challenge.
And I'm going to go, Dr. Lindsay. Or I have a final question that could be a super bummer, but maybe we can spin it to be more positive, or at least I'll try to find a silver lining along the way. One attendee asked, do your results really surprise anyone? The general assumption would be that our system is inherently biased against Black and brown citizens, and certainly one need not spend that much time to find a whole bunch of empirical results showing disparities and biases over race in the criminal justice processing system. But were there some positive takeaways, or at least aspects of the data that weren't as disconcerting as many of these types of findings show? Or at least do you have some optimism that as we've identified these issues, it can make us at least hopeful that bringing the problem to light will lead to more of the players in the system being attentive and seeking remedies? And so not encouraging you to be positive when there's grim stories to tell, but eager to hear kind of your final thinking about what this research shows and how we should come away from it.
I think one main contribution is being able to connect the disparities in sentencing outcomes to treatment court eligibility in particular. That connection just hadn't really been made explicitly in the literature, sort of being able to track, because we see these disparities in sentencing outcomes, this is how this results or impacts drug court eligibility. So I think that connection is one of the main contributions of this study. And then I think being able to say, well, we talk to people who work in drug courts and there are opportunities to try to address this. I think that is one of the positive takeaways, that there are specific strategies that different courts have been able to use to sort of, address or try to sort of correct some of these disparities that they see people coming into their drug court referral systems with. But yeah, I don't know if Dr. Perdue or Dr. Lindsay have other thoughts on that as well.
Yeah, I think even some of the estimates and the percentages that we talked about today honestly weren't as large as I might have been expecting, right? Which I feel like obviously some of them were, right, but not all of them. They were like 5%, 8% is still right. Someone's livelihood and someone's being treated differently, but they're not the 60% that we see with charging decisions and that kind of stuff. And so for me, that was somewhat positive. And I think it's important to know, like, okay, we may not be able to identify which, how, like, is it policing, is it prosecutors, et cetera, but we do know it's something with how people are charged. Like, we can kind of think about charging decisions, maybe it is evidence, maybe it's victims, but we can kind of narrow down where we might focus to help earlier in the pipeline, right? Have people be eligible for drug courts. And so I agree. I do a lot of work about inequality. We know it's there. But unfortunately, we do still have to identify it. We do get the positive outcomes where they're smaller than the disparities seem a little smaller in some areas than we might expect. And I'll let Tasha chime in on the sort of qualitative piece that Lydia brought up that I think is also important here.
Yeah, thanks, Sade. And I would say based on stakeholder interviews that there is definitely some positive notes. So individuals in courts, they're actively working on these issues, and courts are engaging in training related to these issues. Some courts have been sort of monitoring their data, kind of working through some of and the strategies that we really presented. So I think there is real buy-in and a real motivation for courts to really look at this and to assess and to open the program, because we've heard from folks across the state, these programs work, they're very passionate about the work that they do, and they want to make this open and accessible for everyone. So I think they are willing to engage and to implement some of these strategies. And I think also the willingness and interest in learning from other courts. So I think there's a real opportunity for some peer learning to happen throughout the state, and to really, we hope to keep these conversations and discussions continuing in the future.
Wonderful. Well, thank you for presenting that good finishing thought as we look forward and move forward. And to all our presenters for sharing the work and insights. Thank you also for all the attendees for joining us today. We really appreciate the time and engagement from everybody participating in this conversation. And remember, before we close, just a quick reminder that there's going to be a final webinar in this 3-webinar June series talking about this work. The team will continue to build on these topics, share additional insights for practice. Thank you all again for the presentation and for the whole team putting this webinar series together. And we hope those of you who attended today will also attend that final session. Be well, everybody. Have a good day. We made it in an hour, and hopefully you learned as much as I did along the way. Thank you so much.